Assalamualaikum and hi, we are from Group 6 and this video presentation is prepared for our beloved lecturer, Madam Noor FAIZA. Before we get started, let me introduce you our main character for this story, which is also our group member. First is Mimi KARMIELA binti ANUAR, she will be the client. Next, IFTITAH SABRINA binti HAMZAH, the company secretary A, HUDA binti ZAIDI, Company Secretary B, FLORENCE SIAN anak KUDANG, Company Secretary C, and lastly NOOR AMIRAH binti TABSIR, which is the last Company Secretary D. Of today's agenda, first we will discuss on the replacement of Company Secretary. Next issue is changes in the name of company. Next, removal of director before the expiry terms, and lastly, conducting annual general meeting. So without further ado, let's get started.
Good morning. I wanted to discuss the issues we are facing in appointing a new company secretary to replace the current one. It has been quite a daunting task.
Good morning. I understand it can be a complex process. Could you please elaborate on the specific issues you've encountered so far?
Well, one of the main concerns is maintaining the number of our company secretaries in the organization. We want to immediately appoint Mrs. Shaira as the new company secretary before the resignation of the current company secretary, which is Mrs. Sheila. We need to seek procedure in appointing a new secretary while adhering to the company legislation.
Alright, Miss Mimi, let me help you with the first issue you're facing regarding the replacement of the company secretary, Ms. Sheila. So companies operating in Malaysia are bound to abide by the rules mentioned in the Companies Act 2016, which means Louis Tag is also bound to comply with the Companies Act 2016. So based on the statutory requirements under Section 235 of the Companies Act, every company is obligated to appoint at least one company secretary to handle the administrative matters of the company. So, you are not obligated to immediately hire a new secretary after Ms. Sheila resigned. Although I understand your concern to maintain the number of 4 company secretary in the organization. You can do that. So, for the proper procedure, as for the resignation of Ms. Sheila, you need to hold a board meeting to accept the resignation of Ms. Sheila and prepare a resolution to acknowledge and accept the resignation. The solution should be passed by the majority of the director present at the meeting, and then only you may appoint a qualified and suitable company secretary candidate, which you did appoint Ms. Shaira. So then she needs to perform the due diligence before accepting the appointment with the relevant documents that being prepared by Louis Tag. So once Ms. Shaira has accepted the appointment to be the new company secretary, she will need to send you a notice to confirm the appointment. Next, Ms. Shaira needs to prepare some documents to be signed by the directors regarding the decision of replacement of Ms. Sheila and ensure that the documents are signed. And then you need to notify SSM of Ms. Sheila's resignation and the appointment of a new company secretary, Ms. Shaira, within 40 days of the appointment with the prescribed form prepared by SSM along with the signed letters of resignation from Ms. Sheila and a signed letter of appointment of the new secretary, Ms. Shaira. So once the SSM has approved the reassignment of the company secretary, Ms. Shaira will send you an email to confirm the change. After that, in order to reflect the changes to the company secretary position, you then needed to amend the company's statutory records, including the register of directors, register of secretaries, and also register of members. You will also sign a board resolution for the change of registered address to change the registered office from Ms. Sheila's address to Ms. Shaira's. A registered office is the company secretary's office where all official notices will be sent. Ms. Sheila will also need to hand over all the company documents to your new company secretary. Lastly, you need to notify the company's auditors, banks, and other relevant parties about the changes in the company secretary. Provide them with the updated contact details and any other necessary information. Hope you are clear with my explanation, Ms. Mimi.
That's a good suggestion. It is important to ensure that a smooth transition from the current secretary to the new one. Next, I will address concerns regarding the company's name change from Louis Tech to Smart Technology Berhad, Smart Tech. It is a decision we have been considering, but we were unsure about the steps involved and also the potential issues that may arise. I'd like to know if the new name is acceptable and what procedure and documentation are required.
Okay, Mimi, regarding your concern on change of name, here is a simplified step-by-step guide to changing your company name to Smart Tech. First, let's start with proposing your chosen name, which is Smart Tech, through the SSM online submission. It comes with RM50 ringgit fee. If they approve the name, it will serve you for 30 days from the date notified. Next, you will need to submit your paperwork to SSM within these 30 days along with the pay of RM100 ringgit. Make sure to include your application for name availability and reservation, the email approval of your name reservation, and your application for the name change based on the Companies Act 2016. So once all the paperwork is current, SSM will issue you a notification of the name changing within a day. If you want an official certificate, just ask and pay for the fee. So do you remember that your chosen name shouldn't be violate the subsection 22 subsection 1 of the Companies Act? So this is basically that you can't have a name that deemed undesirable or it is unallowed by the minister. So to make things easy, why not to keep it as a Smart Tech Berhad or Smart Tech BHD, abbreviation of BHD. If there is a chance your chosen name could violate the rule, you will need to change it to something else that doesn't. This requires a special resolution and you have got 6 weeks to implement this change. If you fail to do so, you could face a RM1000 penalty. So now let's touch on the possible legal matters. If any proceedings start before or after you change your company name, they will legally carry on as a normal. Just remember, if your company goes into liquidation within a year of a name change, you must use both your old and new company name in all the communication and advertisement. So I hope this breakdown is helpful. Remember to take one step at a time. Good luck on your name change.
Thank you for addressing our concerns and providing clarity on the name change process. Moving on to the next issue, I wanted to discuss the process and any potential issues we may encounter in removing a director from our company before their term expires. We believe it is necessary for the best interest of the organization, but we were unsure about the legal implication and also the steps involved.
Removing a director before their term expire require careful consideration and adherence to legal requirements. Could you provide more details about the reason for the proposed termination?
So what happened here is that after the change of the shareholders, the new members of the board removed Mr. Ramli, who is the director, before the expiry of his term. So his appointment as the company CEO was also being terminated. So we wanted to handle this situation with fairness and also in compliance with the law.
Thank you for answering my question just now, Ms. Mimi. Let me help you with the third issue regarding the removal of a director before their term expired. According to Section 262, regardless of what is provided in a public company constitution or any agreement between Louis Tech and Mr. Ramli, Louis Tech may by ordinary resolution remove a director from office before the expiry of his term and appoint another in his stead. Section 206 gives an opportunity to the members of a public company to remove a director if they are dissatisfied with his performance. The resolution is passed if it garners more than half of the votes cast. Louis Tech need to take a few steps before meetings. According to Section 206(3), members who want to remove Mr. Ramli as a director are required to serve a special notice or notice of intention on the company at least 28 days before the scheduled members' meeting. Louis Tech shall send a copy of the notice to Mr. Ramli concerned. Section 207(1), who may respond orally or in writing Subsection 2, where he has given a written response, he may require his written response to be given to all members. This is according to subsection 3. At the members' meeting, Mr. Ramli shall be entitled to speak to the members according to the section 207(4). Mr. Ramli may also request his written response to be read out at the meeting if the written response was not sent out to the members. Subsequently, the resolution to remove Mr. Ramli as a director will be put to vote. If it is passed, obtain more than half of the vote cast according to section 206(4). According to section 206(5), if a director is appointed to replace Mr. Ramli, the new director shall be treated for the purpose of determining his time to retire as if he were appointed on the day Mr. Ramli was appointed. It is immaterial whether he was appointed at the same meeting or appointed at a later date to replace Mr. Ramli.
We appreciate your expertise throughout this process. Hence, we can minimize disruption and maintain the trust of our stakeholders. Lastly, I would like to discuss the proper procedures for conducting our upcoming annual general meeting. Additionally, I would appreciate an explanation of the role and functions of the company secretary during the annual general meeting.
Now, I would like to explain the proper procedure for conducting the annual general meeting, which is AGM. First of all, AGM is an official occasion at which the board reports on the company's operations and activities, as well as how the board has acted on behalf of and in the interest of the company's members. Under the Companies Act 2016, the company should hold AGM within 6 months of the company's financial year and not more than 15 months after the last preceding AGM, and provided that it holds its first AGM within 18 months of its incorporation. So, to conduct AGM, we should consider 3 parts in the meeting, which are before the meeting, during the meeting, and after the meeting. Company secretary plays an important role during the meeting held. Basically, first part before the AGM starts, the company secretary must assist the chairman with pre-meeting preparation. That includes the scripts that cover procedural matters and alternative scripts to cover matters which may arise at a meeting. Before the Q&A session, the company secretary has to prepare briefing notes summarizing answers on questions which may be raised by shareholders. Besides, the company secretary needs to assist the chairman with what he may need to decline or to disclose in response to questions and what may need to be announced prior to the meeting. We also need to prepare documents at the meeting in case the resolution requires the chairman to open the documents. For example, documents of Companies Act 2016. Before the meeting, it is important to send the notice of the annual general meeting to all members along with necessary forms and check their attendance to ensure that all the directors are aware of the time and date of the meeting so they are able to attend the meeting. Annual report is a compulsory document that should be prepared in the meeting for the consultation. Second part is during the meeting. Company secretary has to make sure that no authorized person enters the general meeting. We also have to read the notice convening the meeting. Moreover, we help the chairman by supplying necessary information. We also need to help the chairman to conduct the meeting to run smoothly. Throughout the meeting, the company secretary has to take notes of the proceeding, such as taking notes on a review of the financial statements. The last part is after the meeting. So, after the meeting, all the minutes that have been prepared by the company secretary should be signed by the chairman. We also have to execute any decisions and resolutions that have been made during the meeting. Lastly, The company secretary should file necessary documents with the registrar and incorporate the alteration, if any, that were made in the memorandum or the articles of association passed in the meeting. I hope you can understand all my explanation.
Excellent. We value your guidance and support as we navigate through these important decisions for the betterment of our organization. Excellent. We value your guidance.
I'm glad I could provide you with the necessary information. As the company secretary, I will work closely with you to ensure that our AGM is conducted smoothly and in compliance with all relevant regulations. If you have any further questions or require assistance, please don't hesitate to reach me.